managing the what now professionalism demands for the in-house counsel. I think we can all understand the need for what's now, what right now, as well as based on the number of name tags and people here, obviously professionalism credits are as popular as courtside seats at a Raptors game at this time of year. I'm Daniel Greenberg. I'm the general counsel of SAP in Canada and a board member of the ACC Toronto. I'd like to thank our sponsors, Goodman's, for this, who have graciously offered to host this event for us and for other clients in in-house counsel. I've had the benefit of a sneak preview of some of the presentation materials as well as the chat that we're going to have. It's going to be, as Peter has told me and other people, it's going to be more open and hopefully immersive and dialogue inducing, as well as moving along rapidly throughout the presentation so that we can all get the benefit of being here and coordinating with each other in a social type of environment as well. For those not familiar with the ACC, the ACC is a global bar association that promotes professionalism and business interests of in-house counsel. It's present in 85 countries and has more than 40,000 members. In Canada, the ACC chapters are in Ontario, Quebec, Alberta, British Columbia. In Ontario alone, we have more than 800 members. If you're not already a member, which I highly encourage you to become, you can join the ACC. There are three compelling reasons to do that. Firstly, it provides access to additional continuing legal education programs developed specifically for in-house counsel. The programs include not only CLEs, but also online programming and other events, particularly the annual meeting, which I've attended a number of times. It is incredibly helpful for gaining all of your continuing legal education credits, but it's also a great way to network across the border with colleagues from around the world. Particularly for me, in a multinational law practice with our other affiliates, I have the opportunity to meet some of my other colleagues at those types of events. This year's meeting coming up is in Arizona. It's in October 27th through 30th, and everyone is welcome to both join the ACC and to attend the annual meeting. I will hand it over to Carly to introduce each of the panelists. Is that okay, Carly?
Perfect.
Okay. There you go.
Excellent. Thanks so much, Dan.
Oh, you're going to do it?
Thank you. Thanks, Dan. And on behalf of Goodman's, it's really a pleasure to welcome you all here today. We're really thrilled to see that so many people are interested in these topics, or as Dan said, interested in getting their professionalism credits at the end of the year. Either way, we're happy to see you all today. And just before I introduce the panelists, just a few administrative items. When you came in and got your name tag, you should have received a certificate of attendance that you'll want to hang on to just in case you're lucky to get audited by the LSO next year. There are also instructions with your name tags that will tell you what to enter in the LSO portal so you get credit for today. And on your tables, there are some feedback cards from the ACC, and we do encourage you to fill those out and drop them off at the registration table on your way out. And for those of you on the webinar, all of those materials will be listed in the downloadable materials at the top of the WebEx. So moving on to our panelists, beside me I have Ryan Guptill. Ryan is an associate principal at Navigator, which is a high-stakes public affairs and crisis management firm. And Ryan has joined us here today to give us a perspective on managing reputational risks, both for the organization and for yourselves as individuals. Then beside Ryan, I have Lauren Budeye, then Tamron Jacobson, and Francie Kussner, each of whom is a partner in our litigation group here at Goodman's. So today's program is going to focus on some of the really challenging ethical dilemmas that can come up for in-house counsel, particularly in a world where your organizations are subject to increasingly complex, often multi-jurisdictional regulatory frameworks, and in a world where the public and the media have a real interest in keeping tabs on whether your organizations, are doing the right or the moral or the ethical thing in the face of these tough situations. We're going to focus on three areas today. First on dealing with whistleblowing in your organization, then dealing with crossing the borders with sensitive and privileged information on your electronic devices, and finally dealing with harassment complaints and investigations in the workplace. And without further ado, I will hand it over to Francie Kussner.
Thanks, Carly, for that introduction and for setting the stage. Whistleblowing policies are an important part of any legal compliance program. Whistleblowing continues to make headlines both in the public and private sector, with a focus on the role of the whistleblower, or in some cases, the lack of one, where there should have been one. We saw that just a couple of weeks ago with the Deutsche Bank investigation into money laundering. When these things hit the press, the questions people always ask are, who knew? When did they find out? What did they know? And what did they do or not do about it? For the purposes of today, we'll focus less on how to formulate a policy, since most of you probably have lots of experience with that, and more about in-house counsel's role in whistleblowing situations, whether as a person in the up-the-ladder chain reporting, or as the person bringing forward the wrongful act or blowing the whistle. To set the stage for our discussion, we thought we'd cover a few foundational concepts about whistleblowing generally, and layer on top of that the rules that lawyers and in-house counsel need to keep top of mind when dealing with whistleblowing situations. What we would like the whistleblowing landscape to look like is that: one framework, one convenient regime to report, consistent protections for whistleblowers and organizations alike. At least in the public sector, that is somewhat the case. Canada is among the 41% of OECD countries to provide dedicated public sector whistleblower protection. However, most of you here likely fall under the private sector, whether in publicly listed or private companies. So for today, we're going to focus on the private sector, which sadly looks a little more like this. Contrary to the public sector, there is no general framework for whistleblowing or for protecting whistleblowers at either the federal or provincial level. Instead, the private sector is subject to a mishmash of statutes, case law, and policies. On the front line in the private sector is the organization's own corporate policy or code of conduct, and these have proven to be an important tool for whistleblowers. Although not mandatory for Canadian companies to have a corporate whistleblowing policy, most, if not all, publicly listed companies do, as a matter of good compliance, have whistleblowing policies, as do private companies. Obviously, Canadian companies that are listed on foreign exchanges need to ensure that they comply with the securities laws of that jurisdiction, which may indeed require whistleblowing policies. For example, companies listed on a US exchange must comply with the Sarbanes-Oxley Act, which requires audit committees to establish procedures for reporting, accounting, or auditing concerns. There's two aspects of the laws and policies that work hand in hand when it comes to whistleblowing. The first is a process to report the misconduct, and the second is protections for the whistleblower against retaliation. To qualify for any protections, an employee must be disclosing information acquired in the course of their employment and doing so in good faith and with a reasonable belief in its truth and accuracy. People acting out of spite, vendetta, greed, or starting frivolous or vexatious claims are not typically protected. Generally, the misconduct being disclosed would have to be of significant impact on the company or potentially on its stakeholders, investors, or the public. Protections available to whistleblowers fall into three categories: retaliation-based remedies, incentive-based models, and punitive models. Remedies against retaliation aim to protect whistleblowers from reprisals such as demotions, dismissals, harassment, or other job repercussions. Some examples of statutes that have built-in protections against retaliation are the PPEDA, the Environmental Protection Act, the Canada Labour Code, and the Criminal Code. Incentive or reward programs are provided by government or administrative agencies, and they not only extend the promise of protection, but they also look to incent whistleblowers to report with rewards, compensation, or in some cases, leniency or immunity. Some examples include the Competition Bureau's Immunity and Leniency Program and the whistleblower programs at the OSC, the National Energy Board, and the CRA. A punitive model would impose liability on people who had the opportunity to disclose and did not do so. This type of whistleblowing policy is much more rare. While protection under various statutes is available to those disclosing to relevant authorities, the reality for private sector employees is that they will report first inside their own organizations, often under the procedures set out in their own internal policy. Internal corporate policies will generally cover the types of issues or conducts that may be reported under the policy. And these will likely include potential wrongdoing in the areas of fraud, bribery or corruption, workplace safety, human rights, product safety, securities, or any other violation of laws, regulations, or course of conduct. The policy will generally outline the process to report within the corporation, and outside services may be engaged in the investigation depending on the nature of the complaint or issue, for example, legal, accounting, or other advisors. And lastly, the policies may outline the protections available for the whistleblower against retaliation. So before we move on to in-house counsel layer to this issue, let's first get a sense of our room with a couple of quick polls. On your devices, go to your internet browser and type in POLLEV.com/Goodmans and answer the following question. You don't have to enter your name, you can skip that part of it. The question is, does your organization have a formal whistleblowing policy? How much time am like 10 minutes. Like you 3 or 4? Interesting. The answer. Good. I can't see it. Okay, just in the interest of time, I'm going to continue. It looks like we've got 50% yes, which is not quite what the OECD reports is the case. So if you guys don't have whistleblowing policies, you might want to look into it. And the second question was, are in-house counsel covered under the policy that you have? And whether as an employee or otherwise. And again, it looks like people aren't sure. Generally speaking, whistleblowing policies don't specifically cover general in-house counsel, but they may be covered as an employee. Okay, I want to turn to the rules of professional conduct, because as in-house counsel, there is an additional layer to be considered in this process, and that is that the duties that the lawyer has under the rules of professional conduct and how these align or conflict with the duties as an employee. A copy of the excerpted rules of professional conduct is available on each table. Many of these rules of conduct are going to come up in the context of all of our scenarios today, so it's worth spending a few minutes reviewing them. As you probably all know, lawyers owe a number of duties to their clients. The ones that immediately come to mind are those of honesty and candor, integrity and loyalty, and of course, the cornerstone of our system of legal representation, the duty of confidentiality. Lawyers would be unable to serve clients effectively were it not for the rule of confidentiality, and this ethical rule is wider than the evidentiary rule of privilege and applies without regard to the nature or source of the information or the fact that others may also share the knowledge. The duty of confidentiality to clients survives and continues indefinitely after the end of the lawyer-client relationship, whether or not differences have arisen between them. We have to keep in mind that the client to whom this duty is owed is the organization, not the officers or employees from whom the lawyer may be taking instruction. This blurring can be more pronounced as in-house counsel, since your everyday interactions are with officers or employees and you have a much closer relationship with them. Equally important to our discussion today is the rule that may sometimes cause an ethical tension with the duty of confidentiality, which states that lawyers are prohibited from knowingly assisting in, encouraging, omitting to take action, or advising a client in relation to any dishonesty, fraud, crime, or illegal conduct. It's worth noting that the rule covers dishonesty, which is arguably broader than illegal or criminal activity. Now, the lawyer's conduct can be actual or also in the form of willful blindness or recklessness. And while you cannot assist, encourage, or participate in the wrongful conduct, it does not follow that you can disclose information to prevent it. lawyers are required to hold in confidence all information concerning the business and affairs of the client acquired in the course of the professional relationship unless the client has expressly or impliedly authorized the disclosure, or under very, very limited circumstances, namely when the disclosure is required by law, or when the disclosure is necessary to prevent harm in situations where the lawyer believes there is imminent risk of death or serious bodily harm, which may include psychological harm. Now, note that this does not include financial harm. In the US, under the American Bar Association rules, where financial harm is going to be impacted, then the lawyer does not have the requirement to keep it confidential. Important to keep that in mind that in Canada that doesn't apply. So what are lawyers supposed to do in the case where they know about wrongful conduct that could have a serious impact on the organization, the stakeholders, or the public? And while the general rule is that they are to keep the information in confidence, even in the face of illegal or wrongful conduct, Rule 3.2.8 provides that a lawyer has a duty to report up the chain of command that the conduct is or would be dishonest and must be stopped. And that rule sets out the process by which they report up the ladder. And this approach of go to the top and stop is important to remember. So, if it isn't already obvious, there is an ethical tension for in-house counsel between the whistleblower regimes generally, the fiduciary duty to clients, the duty of confidentiality, and the duty to uphold the law. But ideally, the organization has hired you to help them comply with laws, will value your advice, and will follow your instructions. But what if they don't? Then what? Before you look at the scenario, let's hear from Ryan.
Sure. So as general counsel, you face two sides of the coin on this issue. The first is when you are approached by a whistleblower or to manage an issue with a whistleblower, and the second is when you yourself find yourself in a situation that you need to report. For the first side of the coin, I would say that there's a level of expectation from the public and media that's higher than regulatory frameworks put out. They expect you to deal fairly and quickly with whistleblowers, and there's also an inherent instinct with public and media that whistleblowers are acting in good faith and that they should be believed. What we've experienced is often organizations become paralyzed and defensive when they're first approached with whistleblowers, but that's the exact wrong approach to take. You should deal with it in a transparent manner and one that's quick to deal with the issue, because at some point it may become public and you need to be able to explain all of your actions. And if you feel comfortable explaining your actions, then you'll be fine. The public understands that bad actors exist and that things happen beyond the control of an organization. So what matters to this is your response. If you act in good faith and you respond quickly, the public will forgive you and be able to move on. But if you try to mislead or waylay an investigation, it could permanently damage the reputation of your organization. On the other side of the coin, on your responsibility to report, I think they align completely. Your interest in reporting will always align with the reputational risk for yourself and for the organization.
Thanks, Ryan. On the tables, there is a scenario for each of the topics. The first one should be the whistleblower scenario. There should be enough for everybody at the table. So if you could have a look at the scenario, I won't take the time to read it. You could just read it to yourselves. I'd like you to read the scenario and consider what should happen next and what might be your obligation as in-house counsel.
So when you're done reading through the scenarios, we're going to give you about 5 minutes to discuss the matter at your table. And for those of you on the webinar, we would love if you would type in your comments and your questions into the chat function, because we will be reading those and we'll be reading them out to the room.
So while you're talking amongst yourselves, the items to consider, as I said, are what should be done next, what might be your obligation as in-house counsel, what protections do you think you have, and what are the various ethical issues at play here?
Okay, so it looks like there's been some good, lively discussion. So before I volunteer a table to share their thoughts with us, are there any volunteers who want to tell us what they would do? Going once. Chris Armstrong, it looks like your table was lively. Oh, yeah. Oh, right. I should mention, because we're recording, I'll just ask that you wait for someone to bring you a microphone before you start speaking.
We were discussing that the duty of confidentiality continues even post-termination, and that obviously conflicts with disclosing anything to a public authority. So we thought the right course of action was to try and work within the organization up towards the board level to address this issue.
Great. Amalia, it looks like your table also had lots of discussion. Would you guys have done the same thing, something different?
We thought that it might be helpful to have some facts. For example, what happens in terms of timing, and was this general counsel being walked out the door right then and there, as opposed to maybe having a little bit of time to work at the desk as yet, and would that change things in terms of having a duty to disclose whether they're still in or out of the organization? Another consideration that was raised was whether or not this was a public company or a private company, and if so, if that would maybe change things up in terms of the duty of care. So those were a couple of major points that we wanted to get your thoughts on.
Great. Francie, did you want to respond to that?
Yeah. I guess in answer to, in this scenario, let's assume that you don't have time to go back to your desk. Assume that you're being escorted out. And assume that it's a public company. I don't know if that changes your analysis. There was a case in the U.S. Where the company was called BioRad, and actually the appeal was just heard 2 weeks ago. So we'll have to wait and see what happens at the appeal level. But it was a California case, and there were irregularities in the financial reporting, and the in-house lawyer couldn't get the attention of anybody up the ladder and ended up going to the authorities. And the question was whether, and when he was fired, he sued and wanted to bring out what had happened as a basis for arguing that he was improperly dismissed. And there was a whole analysis as to whether confidentiality trumped the obligation to whistleblow. And in that particular case, the judge held that he didn't have to keep it confidential, and that it was appropriate for him to have done what he did, and the company had to pay him $8 million. Needless to say, the company has appealed it, and we'll have to await the result. And that is in the U.S., and we know that in Ontario, you're not going to be told that your duty to whistleblow trumps confidentiality.
Not yet. Yeah, maybe if we could just get a microphone.
Yeah, one issue that I often am confronted as general counsel is sort of distinguishing basically very important breaches of legislation, for example, and less material. And day to day, there's often situations where I'm being asked, is this really worth, is this non-compliance really just material or not, basically? Of course, when we're dealing with bribery like this, it sounds like it would probably be significant. But one thing in this case that made me think that maybe this would be significant and would be worth bringing to the authorities after being fired would be the issue that this is a medical device company. So if we're talking about a health issue, like the safety of the device in a market like India or China, and if those bribes basically caused a unsafe product to be marketed, then perhaps I would actually bring that to the authority, because there's broader public safety issues here. So I don't know, the facts don't actually talk about that, but possibly.
Right.
That's a good point. If it is going to result in physical harm as opposed to just financial harm, then it might be a separate consideration. I think that we were thinking here just financial, but that's an interesting angle.
I think it's important to consider how the public would receive this, right? And your own personal reputation in this. If you're sitting on something and you've, first of all, been terminated, which is never good on a CV, and secondly, that you've sat on something and if it becomes public in 5 years and it comes out that you never disclosed or appropriately managed something, that's personally damaging. So it's personally damaging for you, but it's also damaging for the organization. So I just think that there's something to consider there in terms of how you manage your own reputation through that process.
Excellent. Great point. So now we're going to switch gears. I'm going to hand the table over to Tamron Jacobson, who's going to speak about crossing the border with privileged and sensitive information on your electronic devices.
Hi, everyone. So the starting point for this area is that the Supreme Court of Canada and the United States Supreme Court have said that random searches at the border are acceptable because there's a reduced expectation of privacy in that context. But most of the legislation and case law in this area were developed in the context of searching physical items, like a briefcase of documents. Things have become much more complicated with the rise of smartphones and laptops, and neither Supreme Court have yet dealt with the issue of searching electronic devices at the border. Think about what's contained on your smartphone. It's not limited to documents relevant to your travel. It's got calendars, contacts, text messages, emails, photographs. And then there's apps to access even more content, like your banking information, your Facebook, your Dropbox files, your Amazon purchase history, or the embarrassing number of times you've ordered Uber Eats this month. It's a totally different world than the briefcase of documents. I'm going to give you a quick high-level update about the current status for searching electronic devices at the US and Canadian borders. The Canada Border Services Agency, or the CBSA, does not make its guidelines generally available to the public. I'm going to tell you about what appears to be the current guideline for searching digital devices, last known to be updated in February of 2017, with the caveat that it may change at any time and without notice. The guidelines say that currently a search should only be done where there is a multiplicity of indicators that evidence of contraventions may be found. And there's no list of indicators in the guidelines, but here are some of the ones that have been gathered from various sources that may apply to lawyers and business executives. You're a single man traveling alone. Your ticket was purchased in the day or two before travel. You have an unusual travel route. You have multiple electronic devices. You're nervous, agitated, or talking too fast, or you're being hesitant in answering questions. Now, if you're stopped, the guidelines say that officers may ask you for your password and may detain your device if you refuse to provide it. There's also a section in the Customs Act which makes it an offense to interfere with, hinder, or prevent an officer from doing anything that they are authorized to do under the Act. A couple of years ago, someone was arrested under this provision on the basis of failing to provide a password, but there was ultimately a guilty plea in that case, and so the matter was never heard in court. There's a pretty decent argument that it is unconstitutional to demand a password to search your electronic device, but something tells me you don't want to be our test case. Although if you do, let me know and I'd be happy to take it on. Some good news about the policy is that it does direct officers to put the device into airplane mode before searching the device. And this is consistent with a BC case which found that the authority under the Customs Act to search goods did not extend to data that was accessible from but not stored locally on the device. And so at least for now, my Uber Eats history is safe. But this still leaves a huge amount of information available. Even on airplane mode, things like Facebook and Twitter will show recent feed information. And more importantly, for our purposes today, a huge amount of email can be stored locally. The guidelines suggest that an initial search is supposed to be cursory in nature and only increase in intensity based on emerging indicators, which are also not listed in the guidelines. And although the search must be linked to customs and immigration purposes, in some circumstances, what is ultimately found on your device can be provided to other agencies. The guidelines themselves don't mention anything about privilege, but there is another CBSA policy not specific to electronic devices that deals with privilege, and it applies to documents that are marked solicitor-client privilege, are addressed to or from a law firm, or the one that's most applicable today are documents that are carried by a lawyer and privilege is asserted. And so the policy provides that officers should not normally open these materials, but can do so where there are reasonable grounds to suspect that the package also contains non-privileged documents. It's not particularly helpful for something like a smartphone, which will definitely contain both privileged and non-privileged documents. And there appears to be no guidance, at least that's publicly available, about what officers are expected to do in that circumstance. The policy does say that where there is an assertion of privilege and there are reasonable grounds to expect that the documents contain contraband, the documents or device should be sealed and set aside for a court to review. Bottom line is that while border agents should be alert to issues of privilege, the law and policy is very unclear about how to deal with something like a lawyer's cell phone. It's possible that you may be let through without your device being searched, or it's possible that you're delayed and your device is detained until the matter is sorted out. Perhaps unsurprisingly, in the current political environment, Canadians are often more concerned about issues at the US border. The United States Customs and Border Protection, or the CBP, updated its official policy on electronic devices in January of this year. One of the differences between the US and Canada is that the US policy does not require a multiplicity of indicators to conduct an initial search. It can be completely random, but there are a number of similarities between the two countries. So if there's to be an advanced search, which is defined in the US policy as connecting it to external equipment to review, copy, or analyze the contents, there has to be reasonable suspicion of a national security concern or activity in violation of the laws enforced by the CBP. Like the Canadian guidelines, routine searches must be limited to information that's stored on the device, and officers are not permitted to intentionally use the device to access just remote material. Also, like the Canadian guidelines, agents can request your password, and it's not entirely clear what happens if you refuse to provide it. I will say that in the context of the US border, if you have any issues at the US border, you can be flagged for to be subjected to heightened screening every time you cross the US border in the future, so refuse at your own risk. Unlike the Canadian guidelines, the US policy does specifically deal with searching of electronic devices in the context of solicitor-client privilege. Unfortunately, you're not going to love what it says. First, there's no clear direction not to search privileged materials. The only explicit limit is that officers can't retain copies of privileged information unless there's an imminent threat to Homeland Security. And second, while it's possible you may be let through if you say you're a lawyer, the policy says that if solicitor-client privilege is claimed, officers are supposed to contact CBP lawyers who will then coordinate with other offices, establish some sort of filter team, and so that they can be sure that privileged material is handled appropriately while ensuring the CBP accomplishes its critical border security mission. I don't know about you, but when I hear this, it sounds like I'm going to miss my flight. And my desire to quickly cross the border without issues bumps up against my and your professional obligations as a lawyer and the rules of professional conduct you heard about from Fancy, which require you to keep client information confidential. There's a question about whether a request by border agents would constitute the except as required by law exception to this rule, and thus far the Law Society has not provided any guidelines in this regard or let us know what precautions they expect lawyers to take in this circumstance. The only thing that's available is some Law Society podcast which suggests having 2 laptops or cell phones and traveling with a clean device, and that's the only guidelines that we've had from the Law Society. One last thing I want to touch on before we get into the scenario is statistics related to electronic searches. Canada only started to record information about the number of searches last year, and the information is not yet public. But some data was obtained under a Freedom of Information request by the BC Civil Liberties Association, and that data suggests that from 4 months of tracking, an average of 40 devices are examined each day, and an average of 13 are subjected to a more detailed search. In the US, they have been releasing data about the number of searches for the past few years. In 2017, a little over 30,000 searches were conducted, which works out at odds of about 1 in 13,000. better odds than winning the lottery, but it seems pretty low. It might be interesting to note that the 2017 numbers are a 50% increase from the 2016 numbers and a 350% increase from the 2015 numbers. So unlike your chances of winning the lottery, it appears that your chances of winning a random phone search seem to be getting higher each year. What is not collected, or at least not made public by either the Canadian or the US side, is demographic data about searches. Although there ought not to be any discrimination on the basis of things like race, religion, ethnic or national origin, it would be interesting to see those statistics, as I imagine there might be certain groups of people that are subjected to searches more often. Unfortunately, there's just no objective data about it, and it's incredibly difficult to make a case for discrimination without objective data, and especially when it's very easy for border agents to explain away how they came up with their multiplicity of indicators and why they conducted the search in the first place. And so one of the things I want you to think about in the scenario, amongst the things that come up easily, are whether your advice or thoughts on the issue might be affected by the race or religion or other characteristics of the person who's subject to it. Ryan, do you want to add anything?
Yeah, sure. So when I thought about this, I thought about the issue a bit more broadly than privilege. I thought about it in terms of data and the push and pull that's happening right now between heightened media focus on protecting data and protecting information and external forces trying to access that information, which is something you as gatekeepers are facing more and more. We've done some research on data breaches and such, and we've actually found that the general public while they expect organizations to protect their data, there's very little concern when data is breached as long as you deal with the consequences appropriately. That being said, the big issue with this that I would identify would be that sensitive information about personal information from a client perspective, or like market moving information could be leaked and it could cause reputational damage, but I think the chances of that are pretty low. That's my perspective from reputation.
Thanks, Ryan. Okay, so if you can look on, you should have in your package behind the first scenario another scenario, and we're hoping you can take a few minutes to read it and then discuss the issues that arise at your table.
Okay, so I'll just draw everybody back in. I know this is a tricky one. So I'm going to start off with a quick poll. So can you raise your hand if you would tell your CEO, yes, this is a good idea? So for those of you on the web, not a single hand is up in the room.
Wait, no, oh,
is there one?
We've got a couple.
Two brave hands. And well, maybe people just aren't participating. How many would say, no, this is a bad idea? Okay, so, well, Neil, you're all confident enough to take this position. Okay. So I heard right at the beginning there was a resounding no from this table. Can you tell us why there was an immediate no instinct? Oh, sorry, we'll just bring you a mic. Thanks, Amanda.
I guess we just thought it would be a really dumb thing to do, that she'd miss her flight for sure, and she may be obstructing their investigation, and it would be just a whole world of hurt to have to deal with that. So we thought it was a bad idea.
Right. The question of whether or not it's obstructing an investigation, I think, is actually a good one. I don't know, Tamara, if you want to comment on that.
I mean, I would be a bit concerned that this is, more so than refusing to provide your password, I would be a bit concerned that this is getting into the realm of hindering or obstructing an investigation, but it's on the border. I think you could argue both ways.
And from the yes crowd, all two of you.
Okay, well, I think that she doesn't have to bring any information across the border. You know, if she gave them, if she went with a cell phone that was basically broken and crossed the border, would that be hindering the investigation? Not necessarily. And a wonderful thing for this CEO to say, once she gives the border police the cell phone, is turn around and say, "You guys broke my cell phone now."
So the one thing I will say that you should be careful, and I was thinking about wording this scenario in terms of giving the officer the wrong address, but I didn't want to raise another issue. But that, just to point out, lying to an officer is definitely against the law. So don't do that. But you raise a good point. For sure, there's nothing wrong with deleting your data before you go into customs, before you cross the border. It's just getting into the gray area of whether once you've been asked, it's almost, I think of it like you're carrying a briefcase, somebody asks to see it, and you start eating your document that's in your briefcase. sort of similar, but it's an interesting point.
Any other comments from the crowd? Yeah, Peter.
The only thing I'd suggest is if you do erase your cell phone before crossing the border, when you get there, don't re-download everything from the Wi-Fi contacted in the hotel. Probably done a lot worse.
And Ryan, I think you had some thoughts on this also.
Again, just
if you'd like to.
Just, I don't think, yeah, I mean, in terms of sensitive information leak, like that's what my mind goes to, and it's possible, but I just think it's unlikely that a border guard would ever retain the information and leak it. So I just don't think, from a reputational perspective, it's that challenging, except for breaching privilege, which is in and of itself a challenge for all of you.
The other concern I'd have with that particular scenario, putting aside whether it's hindering an investigation, is also that I'm not sure exactly how it works, but it may be pretty obvious to the border guard that you've done this, which I think can lead to a lot more problems than it's worth. So I did want to talk just briefly about what can you do instead of this. Many guides recommend not taking electronic devices across the border. Like hundreds and hundreds of reports I read did this. This seems to me to be a pretty not practical solution for lawyers and business executives. You could do what the Law Society suggests, which is have 2 devices, use one just for travel and keep it clean. But really the best thing you can do is to remove unnecessary data before you go into customs, before you go into pre-clearance. And if you're using a phone with cloud backup, you could restore your phone to factory settings and back up once you get across the border. If you don't want to do that for your entire phone, you can delete just your work email account and just restore that when you're across the border. Most tech departments can do that remotely. Ultimately, the precautions you take or you don't take might depend upon how sensitive the data is and whether the information on your phone is the type that customs agents might be interested in. So for example, if you're an immigration lawyer, a criminal lawyer, or your company deals in things that the government might find interesting, you might want to take the highest level of precaution than if you were at a run-of-the-mill company. And as a last resort, if an agent asks you to search your phone and you've taken no other precautions, consider telling them that you're a lawyer, that you have solicitor-client privileged materials on your phone, and that you're asserting that privilege on behalf of your clients. It may not prevent them from reviewing your data, but it will at least provide you with an argument to the Law Society that you took reasonable steps to protect privilege. Although I can't promise you won't miss your flight.
Okay, thanks, Tamara. So now we're going to move over to Lauren Budai, who's going to talk to us today about workplace harassment and investigations.
So thank you. We could probably have a day-long CLE on this topic and still would be unlikely to address all of the various ins and outs that concern sexual harassment in the workplace. However, what I am hoping that we're going to be able to accomplish in the remaining time that we have is to come back to highlighting the various tensions that arise for in-house counsel should your organization be faced with reports of or complaints of sexual harassment. Sexual harassment's illegal. Sexual harassment in the workplace is illegal. This is not new. However, with the most recent media attention, the advent of #MeToo movement, certainly it is has been brought fore in the public's mind and has brought the issue into sharper focus. We need only reflect on this year's past media coverage involving Harvey Weinstein, Kevin Spacey, Mario Batali, Matt Laurie, Charlie Rose, to illustrate this point. But there's also been recent changes in the legal landscape that have helped bring the issue of sexual harassment out in the workplace out into the light a little further. Given our time constraints, I'm going to limit our discussion today to the recent changes to Ontario's Occupational Health and Safety Act. But I would add that in jurisdictions across Canada, there exist positive obligations on organizations to provide workers with a workplace that is free from sexual harassment and other obligations with respect to policies, reporting, investigations, and the like. So as a result of the changes to Ontario's Occupational Health and Safety Act, organizations are now required to have a policy with respect to workplace harassment, among other things, and also to develop a program to implement that policy that includes elements regarding reporting and investigations. And as a result of these recent changes, there is a new requirement for organizations to investigate incidents of sexual harassment, and that duty or obligation to investigate and make inquiries exists whether or not there's a formal complaint filed. Gone is the day of I have to tell you something but don't do anything. Also related to these recent amendments and to the obligation or the duty to investigate, organizations are required to inform both the complainant and the alleged harasser in writing of the results of the investigation and any corrective action that has been taken or that will be taken as a result. For a number of organizations, many organizations, I suspect this presents a significant change to the way in which incidents of sexual harassment in the workplace are dealt with. And for in-house counsel, certainly, in addition to having to help your organization come into compliance with these obligations, suspect that these create new tensions or potential tensions for you in having to balance your legal compliance obligations and your professional responsibilities as counsel. So let's talk the Act's requirement for an organization to conduct an investigation into incidents and complaints. Specifically, the Act says to protect a worker from workplace harassment, an employer shall ensure that an investigation is conducted into incidents and complaints of workplace harassment that is appropriate in the circumstances. Now, what is appropriate in the circumstances is not expressly defined in the Act, and as you will understand, it's inherently fact-specific. So it is going to fall to in-house counsel to consider, in the prevailing circumstances, what that investigation may or may not need to look like. Can it be informal? Should it be formal? Can it be done internally, or is it something that the organization needs to consider to take external? And what would the scope of the investigation or the mandate of the investigator, and what's the timing of that investigation going to be? So certainly beyond our scope today to go through the various details of best practices in conducting an investigation, there's little doubt that under the Act, the organization is required to do something, and you as in-house counsel, more likely than not, are going to be involved in some fashion. So I think that against that, we should consider the various tensions that may come to pass and may exist. Taking an example, for instance, a company becomes aware of an incident, albeit absent a formal complaint having been filed, and ultimately determines that it's not going to undertake an investigation, or perhaps murkier still, is going to undertake a very, very cursory investigation. You consider your obligations as counsel then, obviously, as we've discussed, and we won't go through in detail, but you are aware of your obligation, confidentiality, and protect your client's information. But you are equally, as Francie raised earlier, prohibited from knowingly assisting in, encouraging, omitting to take action, or advising a client in relation to dishonesty, fraud, crime, or illegal conduct. So to the extent that you as counsel become aware of illegal conduct within the organization, you may be required to take further steps. As Francie indicated, there are sort of the chain of go to the top and stop, and these are certainly will pose potential issues for you. Additionally, I'd note that as counsel, you have an obligation to avoid conflicts of interest. The rules of professional conduct define conflict of interest as, to include the existence of a substantial risk that a lawyer's loyalty to or representation of a client would be materially and adversely affected by a lawyer's own interest or duties to another, and the risk must be genuine and serious. Now, one thing to keep in note is that personal interest conflicts fall under this rule, and as in-house counsel, no doubt you know that over the course of your work, you develop deep personal relationships, long-standing relationships with individuals within your organization. And as such, depending on the identity of the complainant or the alleged harasser, as in-house counsel, you may need to excuse yourself from participating in the investigation, the review of the report, addressing the complaint, and certainly potentially in even conducting an investigation. I should also add that should the parties involve perhaps members of the organization's legal team, you'll also be required to recall Rule 6.3-3 of the Rules of Professional Conduct that specifically prohibit lawyers from sexually harassing colleagues, staff members, clients, or any other person, sexual harassment having been defined in Rule 6.3-0. So just before I turn things over to Ryan for his perspective, I want to highlight one further consideration, and that is the potential tensions that may arise for in-house counsel, and certainly where you'll need to tread lightly, and that's with respect to disclosure obligations. So while an organization should certainly strive to keep the investigation confidential, which will accord with your obligations, depending on the various nature of the incident, the number of witnesses involved, for instance, that's not always going to be possible. Additionally, however, though, there are going to be additional factors such as the identity of the alleged harasser that may end up triggering certain disclosure obligations. For example, it may be necessary for the organization to consider putting the alleged harasser on administrative leave pending the outcome of the investigation. I'm sure you can think of various circumstances in which this may or may not trigger disclosure obligations. Similarly, as we mentioned earlier, consider the need to report and take corrective action as the result of the outcome of an investigation. And again, a decision to have to terminate a senior executive in an organization, depending on facts and circumstances, and the nature of your corporation, your organization, may very well carry with it obligations to disclose and will have to be very carefully considered by counsel. While we do hope that often the advice is taken and followed by, that is given by in-house counsel is followed and taken by the organization, to the extent that an organization fails to make what should otherwise be appropriate disclosure, or in fact makes a decision with respect to the corrective action that it ought to have taken or first decided to take and now chooses not to in order to avoid perhaps triggering disclosure obligations. Again, these are certain instances where you may, as in-house, find yourself having to take action in accordance with your professional responsibilities that are not aligned with those of the corporation. So with that, reputation.
Sure. So I don't think there can be any doubt at all that Canadians see this as a big problem. In the spring, as this issue continued to bubble and organizations continued to deal with it, Navigator undertook some research on sexual harassment and what people expect. expect to happen, both from the organization perspective and what they define as sexual harassment. And I've left some of those on your tables for your consideration. So 35% of Canadians report being sexually harassed at some point in their career. 2 in 5 Canadians say that there is some or a lot of sexual harassment that happens in their workplace right now. To make things even more complicated, I think that there's a big tension between what the law expects and what the public and media expect here, sort of like with whistleblowing, but it's more emotional. The problem is things get gray really quickly. So when it's something as serious as sexual assault, it's a very black and white issue. You know the process, people understand that it's how to deal with it, and it's dealt with aggressively. When you take the definition of sexual harassment to the general public and how to deal with it, it becomes a lot more confusing. So on issues like making jokes of a sexual nature, whistling at someone, or making comments about how someone is dressed, significant portions of Canadians fall on either side of the issue. That makes the tension that you're dealing with difficult because you have to sort of juggle between a legal and reputational risk when you're dealing with these things. What I would say the most important principle is to operate with the principle that one day it might be public and that you may need to do a TV interview on this, and you don't want to have any. You don't want to obfuscate, delay, or complicate. Be comfortable explaining your actions. And fundamentally, I think that these things get overcomplicated quite a bit. Act like a normal person would act. So sympathize with the complainant. Tell them that you're going to find a path forward. Reiterate your commitment to a safe and secure work environment. And attempt to find a solution that helps the victim. Fundamentally, like I said, it's just a very simple issue, and this is a rule. It's a bit hokey, but it's what I've used with clients before, and it's true. I call it the grandma rule. If you can explain what you did to your grandma, and she'll still tell her friends about it, how proud she is of where you work, you've managed the issue well, and that's sort of how you should operate whenever dealing with issues like this.
Okay, so there should be the third scenario that you have before you, and what I'd ask as you have a look through it is to consider, as in-house counsel, what do you do? What are the duties that you have to balance? And much as in the other scenarios, take advantage of the experiences and the insights of your colleagues and talk about it amongst yourselves for a few minutes.
Okay. Looks like there was lots of good discussion on this one. So I'll just get everyone's attention back up. It's always hard to quiet a room of lawyers. Talkative bunch. So Ryan, did you want to start us off by telling us how you would advise a client to handle this situation?
Sure. So I guess I'd start by saying each of these is completely contextual. There is a lot of important detail that you need to get and interpersonal information, et cetera. In this situation, I would encourage Christine to act and make it clear that you're willing to act regardless of the consequences for the transaction. But if she asks not to have it occur until after the transaction occurred, and it falls within the letter of the law, I think that you should consider her request to do that. One of the things that I'd be concerned about with compulsory investigations is the re-victimization of someone who didn't want to pursue something. Obviously, the other side of that coin is that there may be other people who are victims out there who haven't come forward, so you may feel compelled to investigate if you have a deeper understanding of somebody's behavior or there's other considerations. And then I guess just one thing that I would say in general is that one thing that sometimes gets lost in the shuffle is usually the interests of the victim align with the interests of your organization, and to deal forthrightly and quickly with their issues behooves your organization in the long run.
So actually, those are very good points, and actually we've had a comment from the web as well that certainly thought that this should be dealt with quickly, and that to the extent that there should be encouragement for Christine and that there may be other individuals within the organization that need to be helped to come forward. That's certainly a point. So I also have of interest sort of questions for the room. What were people's thoughts generally in terms of whether or not this was an investigation that could be done internally or an investigation that perhaps the organization may want to go externally? And as Carly said, I don't want to volunteer any particular table, but do we have thoughts? Who would have gone internal? Who would have thought this could have been done internally? No one? Who thought that this might be the situation in which an organization should consider going external for the investigation? And a whole lot of people who are unsure or unwilling to commit. So just out of interest, what factors, were there pros and cons that were discussed at this particular table in terms of why you may or may not want to go external versus internal, or was it just a gut feel you knew right off the bat?
You need the microphone.
Grab you a mic.
Sorry.
Just more of a gut feeling because it's a C-suite executive and they're in the middle of a transaction. So trying to do an internal investigation might get very messy.
Yeah, in our research, we found that Canadians very much valued the presence of an external investigation and trusted the results a lot more, probably unsurprisingly.
And I think just to bring it back to some of the hallmark points of today, to the extent that there may be messy or sticky situations, you as in-house counsel being able to go external might help you navigate some of the potential tensions or conflicts that may come to pass in balancing your professional obligations and your duties to your client as well. So that's of interest. One other question, just what about the timing of the investigation? Ryan mentioned obviously respecting to the degree that the law would allow the witness's wishes, but what about the timing of the investigation, whether or not it's in light of financial harm, which Francie has alluded to, but in terms of, do you think you wait? Do you do it immediately? Can you start now and take your time? Were there any discussions at the tables in terms of awkward discussions in terms of how that might come to pass? This has been a quiet side of the room. We volunteer anyone? Any thoughts? Sorry, we'll get you a mic.
Microphone.
Oh, sorry. We were all of the view that it really was a situation that needed to be looked into sooner rather than later, and really to get on it regardless of the transaction.
Okay. And disclosure obligations. Last sort of point, just to perhaps circle around, get your feel. And if you are to move quickly, disclosure obligations, C-suite, by and large, was the discussion at your table something to the effect of how you would deal? Did anybody talk about the pros and cons? Yes? We'll get you a mic, sorry. Just for the benefit of people on the web.
I found it's helpful if within your organization you talk about the disclosures before an actual thing happens. So I, as general counsel, have a path. If there is a complaint about a C-suite, then I go to the chair of the board. If there's a complaint about someone affecting the board, I go to a specific person in the C-suite. So we have always someone to go to, more than one option.
So that's an excellent point. As I'm sure you're all aware, in crisis type or difficult situations, not all parties can act in a calm, rational fashion, and your job as in-house is to bring people back to that level and to help the organization make the calm, cool, rational, reasonable response that's required. And so to have in advance sort of a plan for disclosure and the path that should be taken, certainly I think is an excellent idea.
And it's really important, as you said, to have a plan in place and to have avenues for people to report. But it's also important for organizations to reiterate that commitment and that those options for them, so that people understand in advance of any issue coming forward. And once again, just recommitting to a safe and secure work environment.
So subject to, I think,
I'm looking at Carly.
Questions and yeah.
I'm actually curious about your view on disclosure of, or I guess anonymization of investigation reports. You know, so that the victims cannot be identified. Is that like I've actually had a situation where I was struggling with that versus sort of ensuring that the alleged harasser has the ability to fully defend himself. You know, like what's your opinion on that? To what extent is that okay to anonymize the victims?
So I certainly have some thoughts, although if there's anyone else, by all means, I'm happy to have others pipe in. So there are a couple of distinctions I think that are probably important. So depending on the nature of the allegations, the incidents, the complaint, if there are multiple complainants, it may be something that you are able to present dates, times to an alleged harasser, and arguably either he, in this case, in your case anyways, example, excuse me, ought to know. But there may be circumstances that just you are unable to keep the complainant anonymous in giving the appropriate opportunity to the alleged harasser to respond. And I think the balance there has to be, at the end of the day, a proper investigation to some degree is going to be scrutinized by at least one of the parties, certainly internal to the organization, and to the extent that the anonymization puts the inherent sort of quality of the investigation at risk, it's something that you're going to have to consider. There also, just used the phrase the report. So there is also a distinction, I think, within the organization in terms of the report. That is separate and does not need to be disclosed to the parties. It's the result of the investigation. So whatever internal reports perhaps are prepared for the benefit of the organization, where the names of witnesses and everything are included, that is not something that has to be handed over to the alleged harasser. The results of the investigation can be appropriately crafted so that there isn't that whole-scale sort of destruction of anonymity. I don't know if you have any other thought?
Yeah, pretty well aligned with that.
Okay. Any last minute questions or comments?
Over here. Oh. A microphone's coming your way.
Thank you. Hi, I have a question about the crossing the border situation. Just wondering, in terms of once you provide a password to unlock your phone, but what if you have password protected information within your phone? Like if you have password protected documents, do you also have to disclose passwords for those?
Yeah, so the current guidelines, and this is all guidelines as opposed to necessarily all of these being tested in court. The matter hasn't been tested in court, so whether it's constitutional or not is another issue, but the guidelines and practices seem to be that they can ask for passwords for anything other than remote access. They can't ask for passwords for your banking information, your Facebook account, anything that's going to be accessing remote data, but if you encrypt a file, they can ask for passwords for that, and to be honest, if you don't give it to them, they're going to take it behind and unencrypt it using software, which might take a few hours or days.
You'll miss your flight.
You're going to definitely miss your flight.
Okay, so thanks so much for joining us today. I'll just remind you again about the feedback cards on your table, which we'd love for you to fill out. Also, we did record this session, so if you have a colleague who wants to see this, or if you want to watch it again, you can email the ACC or Goodman's, and we will send it to you.
Hi. And I wanted to thank Goodman's for having this great event today, and thanks for all the CPDs for everybody. I wanted to also remind every member, the ACC members, that there's a holiday party coming up on Wednesday the 19th at the Cambridge Club. That's a members-only event. And I encourage everybody to approach me that's not a member to discuss membership and the benefits of that. Anything else, Alan? That's it. Thank you very much, everyone.
Thank you.